I'm Drew Stevenson, and this is a lecture for my Statutory Interpretation and Regulation class, or Leg-Reg, about the case People v. Smith, a Michigan Supreme Court case from 1975 that really nicely illustrates what we call the Ejusdem Generis Canon. Now, I'm going to explain the canon. The whole case is kind of about that, so we're going to talk about it a lot, but just as a preview, what we're talking about here is a statute that lists a bunch of specific items in one sentence and then says, or any other thing. And the courts assume that it means any other thing like those things that were just listed. And I have a whole other video about Ejusdem Generis and called One of These Things is Not Like the Other, which is, I think, a helpful way to think about this canon. The other thing to keep in mind about the canons is that they are controversial. There was a very influential law review article that's discussed in kind of every casebook for this course back in the 1950s, really attacking or purporting to debunk the canons of construction. And it really won over a lot of judges and law professors. And a whole generation of lawyers were kind of taught that the canons are ridiculous and or are a hoax or meaningless or something like that. But they've had a sort of renaissance in recent years with the rise of modern textualism. So if you think about it, judges who really want to focus on the text and not use legislative history or external sources to help ascertain meaning, end up finding these classic common law rules of interpretation really kind of handy because they are very a lot of them are text focused and are useful rules of thumb or literary sort of interpretive tools to sort out unclear passages in statutes. So let's look at what happens in People v. Smith. And the statute is our real focus here, not necessarily the holding or the facts, but basically, I want you to look at this statute. So it's a Michigan state statute at the time that made it unlawful to carry, quote, a dagger, dirk, stiletto, or other dangerous weapon except hunting knives, basically concealed on one's person or in a vehicle. And all you really need to know about the facts is Smith and his friends were pulled over in a routine traffic stop in Detroit, and Smith had an M1 rifle. That's an old military style rifle from the early 20th century under the passenger seat of his car. These are popular for things like hunting and so forth now. And so they were charged under the statute when the police searched his car and found this gun. Now, I want you to look at that statute with me for a minute. It lists some things and guns aren't there, right? Now, guns are a dangerous weapon, right? So that might fit under or other dangerous weapon. If you're not familiar with some of these other words, a dagger is a long stabby knife, right? Think in movies like the shower scene from Psycho or something like that. So you should think of a long knife like that. A dirk is a traditional Scottish type of knife, typically with a decorated handle and at least one of the edges, but sometimes both, is very sharp. And a stiletto. Now, you may be associating that with high-heeled shoes, but the high-heeled shoes actually get their name from a type of knife that was popular in earlier past centuries because it was so easy to hide in a seam in your clothing or in a boot or something like that. And so these are long, thin knives that sort of resemble a modern letter opener, if you've ever seen a fancy letter opener, except they're made to kill someone and so forth. So all of these things are basically types of knives or stabbing weapons. And then we have an exception for a type of knife that you actually need to have with you when you're hunting. And that's our statute that he's charged under for having his M1 rifle. Okay, so the court cites this statute and then kind of dives in to this canon, Ejusdem Generis. And I know this is archaic language here, and you don't have to call it by its proper term, just like the Latin phrase. Some of the canons have Latin names. This is an old law French name. If you want to know kind of the exact pronunciation, I want you to think about this conversation that I have kind of every semester with some various students, where they come and they say, I'm going to miss an upcoming class session, professor, because I have to attend an event, or I have an interview, or I am traveling, or something like that. And I say, well, like I care, but I usually give the professor answer and say, well, that's fine. I think you're allowed, I don't know, 5 unexcused absences for each class during each semester. And then what does the student say? I used them up already. And so if you think about the way you would say, I used them, that's how actually we pronounce this canon. I used them up, I used them generous, and that's our canon here if you want the old French pronunciation. Okay, so this is a long quote. I know it's 2 sentences. I could have broken it up, but in construing statutes in an effort to ascertain and give effect to the legislative interests, courts are guided by a rule of construction known as Ejusdem Generis. This is a rule, and by the way, the reason I have this on the slide is so that you could see the way this court is defining this canon. I also have a picture from Black's Law Dictionary of how it defines the canon. This is a rule whereby in a statute in which general words follow a designation of particular subjects, the meaning of the general words will ordinarily be presumed to be and construed as restricted by the particular designation and as including only things of the same kind, class, character, or nature as those specifically enumerated. In other words, we have this feature that happens a lot in statutes, like in this case, where they list some specific items covered by the statute or maybe covered by an exception. It could be objects, it could be people, it could be activities, but they're specifically listed, delineated in the statute. And then the legislature doesn't want it to be an exhaustive list, so they say, or any other, whatever, dangerous weapon, or whatever it is. And well, we don't want that to include everything in the world. In theory, if I hit you with my water bottle hard enough, it's a dangerous weapon. But we don't think the legislature, when they say dagger, dirk, stiletto, also meant, or water bottles, if the guy can hit you really hard with it. They may include other types of blades, or the real hard question is, what if you broke a glass bottle and we're using a shard of sharp glass to stab someone? Maybe. But I don't think that the legislature meant it to include the statute to apply to every single object in the world that's being used to endanger someone. That would also include your car, right? So here's another quote. Thus here the phrase or other dangerous weapon except hunting knives adapted and carried as such following those specified types of stabbing weapons, right? All of the things we saw on that list are stabby things. Under the rule would be limited to stabbing weapons. This is a nice example or quote for you to kind of highlight of how a court applies this canon in practice. As to that part of the statute, we see no intent to include firearms of any sort in the phrase other dangerous weapon. Now, here's another kind of expert move by the court, and I don't know if the lawyers brought this up to them, but when you're a lawyer, get your statute, really look at your statute, and then also look at the neighboring statutes or sections of the same act and see if one of those other sections is actually already doing the same thing that the opposing party is trying to stretch your section of the statute to cover. And that's what happens here. The court notes that there's another section of the same act that says any person who, with intent to use the same unlawfully against the person of another, goes armed with a pistol or other firearm. Well, that would definitely cover our M1 rifle. Or, here we go, dagger, dirk, razor, stiletto, or knife, having a blade over 3 inches in length, or any other dangerous or deadly weapon or instrument shall be guilty of a felony. Well, this is a felony, and this is also a specific intent crime, to harken back to something from your first year criminal law class. Notice that this requires the mens rea for this statute is that you intend to use it illegally, unlawfully, against another person, not to do, even, this doesn't even include an intent to do property damage. It has to be, you're planning to shoot or stab someone specifically. And so the problem is that even though this section of the statute would definitely have applied to Mr. Smith's M1 rifle, there's no evidence to think that Mr. Smith and his friends who were out driving around Detroit in his van were planning to shoot someone with that rifle. And so remember, what the way elements work in criminal law, if we don't have the specific intent, if it's a specific intent crime, then we can't get a conviction, right? And that we haven't met the elements. The court then it compares this section to the one that Mr. Smith was charged under, and says what the legislature wanted to do was make it harder to prosecute people who have a gun in their car, because this is Michigan. There's a lot of Michigan is forested, and hunting is a big thing. And so, if you think about it, how would you ever get your gun to where you were going to go hunting? And by the way, I'm not a fan of hunting. I think deer are pretty. I've never wanted to sneak up behind one and blow its brains out, but I understand it's a big thing for other people. And so the hunters here need to be able to transport a gun in their vehicle to where they're going to go hunting out in the woods or the wilderness. And so the court says they put a specific intent element in the provision that applies to firearms, that you have to be intending to shoot someone with it, like kind of on your way to shoot somebody in order to be prosecuted. And by the way, they don't say this, but if you read between the lines, what's going on in this case, and I'm sure the court noticed this, is the prosecutor had picked this the other section, the non-firearm section that only is about stabbing things, probably for the same reason, because it's easier to win a conviction if you don't have to prove a specific intent mens rea element, right? So the other one was either a general intent or strict liability kind of possession type crime. If you have the knife in your car and it's concealed, then we can charge you with it. And so the prosecutor wanted to use that. It's a much easier case to win. You save a step. You don't have to prove what the person was thinking, which, by the way, when you're a prosecutor, is often the shakiest part of your case, unless you have a recording of the person declaring their intent. It's right. It's hard enough to read people's minds, but to read people's minds in the past is very difficult. Okay, back to the canon, a few final words about it. When we have phrases in statutes like the one here, or other dangerous weapon, these are very common catch-all phrases that legislators use to make a list of items non-exclusive. So it's very common when we're drafting modern legislation to list some items we want to be sure are covered. And then, but we don't want to limit it to that. We don't have, right there, maybe there's 100 different types of knives and words for knives. And we don't want to have to mention every single one. We don't have to list switchblade and things like that. So we add this catch-all phrase at the end. Very, very common all throughout our modern statutory codes. But this phrase is intended only to catch things or situations that share the same shared trait that the delineated items have in common, right? So there's something in that list that's the common denominator through all the specified terms. And when we say or any other blank, we mean other things that share whatever that common trait is. Okay, that concludes our lecture about People v. Smith. And again, I really want to point my students to the video at this point you should watch about Ejusdem Generis if you haven't already, so that you can really have clear in your mind what this canon is and how it's different from others.